Hi everyone, thank you for joining today to learn more about the MSO-PC model. We are going to be talking about compliance and scaling as it relates to digital health companies who are interested in either creating the MSO-PC structure or have already created this and are looking to expand in other states. All right, so our agenda for today is going to be, we're going to do a 101 on the MSO-PC model. We're going to talk about the regulatory environment. There's been a lot of changes at the state level in this space, the evolution of the MSO-PC structure, barriers and opportunities, and lastly, scaling. As a reminder, we like to have this disclaimer just to let you know that while we are lawyers, we are not your lawyers unless you've signed an engagement agreement with us. So today's video is for informational purposes only and should not be considered legal advice. All right, so just to get a little bit of a background on what the MSO-PC model is, we are going to be talking about the when, what, and why. So as you can see, the MSO is on the left there, represented by an icon that shows it is on the business and administrative side, and the PC is responsible for all clinical operations. So in terms of when, the MSO-PC model actually has older roots than most people realize, but its popularity and widespread use are much more recent. So the actual conceptual foundation of the model began in the 1950s through the 70s when states first began adopting the corporate practice of medicine doctrine. And we'll talk about that in a little bit. When we approached the 80s and 90s, that's when we saw more of a formalization into the MSO concept. In the 2000s, we saw an increasing use in multi-state provider groups. And when telemedicine began adopting the model in 2015, between 2015 and 2019, that's when we really saw the rise of virtual care startups taking advantage of this model. So more recently, from 2020 to 2022, when we experienced the public health emergency, that's when we saw more of an acceleration and a spike of this model's adoption. And then more recently, between 2023 and this year, is when we've seen this model really become entrenched in the virtual care industry, and states are starting to scrutinize the model to make sure that they are structured compliantly. In terms of the what, so the MSO stands for the Management Services Organization. It provides management, tech, marketing, staffing, and operational support, and more to the PC. The PC, which stands for Professional Corporation, this entity hires licensed clinicians, and this practice entity retains exclusive control of all clinical decision making. You may hear the physician-owned entity described as a friendly PC. This term reflects the practical reality that the MSO's success is tightly linked to the PC's clinical and operational performance. Because the MSO's revenue, long-term viability, and investor expectations depend on a well-functioning clinical practice, the relationship between the PC and the MSO must be collaborative, stable, and grounded in clearly defined responsibilities so that each entity knows what they are responsible for and are compliant in terms of what the state is going to allow. The physician owner is another key piece of the model. This person is responsible for establishing and approving all clinical protocols, supervising and evaluating clinical staff, resolving any quality care concerns or escalations that might occur, hiring clinicians, and when necessary, disciplining those clinicians as well, and also ensuring that the model from a clinical perspective meets standards of care. In some cases, the physician owner may also provide direct patient care, or they might just oversee what's happening in the practice. So why did the MSO-PC model come into place? It evolved to enable non-physician owners and investors who wanted to support practice operations to participate in these organizations without violating certain state-level laws. For example, the corporate practice of medicine doctrine. Most states continue to enforce some form of the corporate practice of medicine doctrine, which restricts unlicensed individuals and corporate entities from practicing medicine, employing physicians and other clinicians, depending on the state, and directing any sort of clinical decision making. The purpose of the MSO-PC model And the corporate practice of medicine in particular has always been to protect clinical independence. So states are of the opinion that medical decisions must be driven by patient need and not corporate goals, such as revenue targets, investor interest, or any other operational pressures. Another reason the MSO-PC model is in place is for licensure purposes. So because the structure is used across multiple specialties such as primary care, behavioral health, dermatology, etc., licensure type matters. So states will often impose distinct rules depending on the specialty, and a compliant MSO-PC model must align with each state's professional scope of practice and ownership requirements. Lastly, because this model involves the participation of two separate corporate entities in a business with a single source of patient revenue, it implicates state fee splitting and kickback regulations as well. So fee splitting laws prevent clinicians from sharing professional fees with unlicensed individuals or entities. So for this reason, the PC cannot pay the MSO a percentage of clinical revenue. The management fee, which we'll talk about in a bit, must reflect fair market value. It can't be tied to the cost or value of any services, clinical outcomes, or visit volume. And the fees need to be supported by valuation documentation. So here's a diagram that shows the structure and how all the parties operate together. The Management Services Organization, or the MSO, is the one that's providing management and administrative services to help operate the PC, which is indicated here on the diagram as the state PE/PC. PE just stands for professional entity because some states allow or require a different designation than professional corporation. You may see professional association or a PLLC instead of a PC. So the MSO provides these services to the PC in exchange for a fair market flat management fee, and that's usually paid to the MSO on a monthly basis. The friendly physician is another important party in this model. They will be owning the state PC, and as we talked about previously, they'll be directing and ensuring that all clinical operations are running smoothly. You will then see payers and patients on the right side of the diagram. So this is meant to indicate that all clinical fees will be paid directly into the PC's bank account, and that's very important. From if the company is enrolled in Medicare, they need to have a separate bank account. Similarly, if they are only enrolled with commercial payers, they would need to abide by state fee splitting laws, which ensures that any clinical fees are going to be coming into the practice. So it is very important that all of these, or at least the MSO and the PC, are separate entities in terms of ownership and control. There could be some risk if there is shared branding, for example, or if there's any sort of interference by the MSO in terms of involving themselves in any clinical decision making. So it's very important that the contracts indicate separation, and in practice that the MSO is only involving itself in administrative and management services. There are a series of agreements that need to be in place in order for this model to run smoothly. So it can be complex when it comes to that point. So it's very important that all your legal contracts and operational processes are in line and compliant with state level laws. All right, so now we're going to talk about the regulatory environment. So federal agencies are actually also getting involved in looking at the MSO-PC model. We now have guidance from the OIG recognizing that the MSO-PC model and other telehealth platform models can pass the Anti-Kickback Statute in terms of complying with a safe harbor if they are structured correctly. So there are some key guardrails that need to be in place. One is having compensation set in advance and being in line with fair market value. There cannot be any referral-based payments. There needs to be a separation of clinical versus non-clinical roles. Payments need to be made in compliance with state level law and the Anti-Kickback Statute or Stark Law if those apply, even if there's no reimbursement from payers. And the model has to be structured in a way that's commercially reasonable so that it doesn't seem like it's a kickback in disguise. That said, that the OIG opinion did not address state law because that is a federal agency. So it's also important to be aware of state legislators and state professional boards who are also working to develop new laws that apply to MSOs and the MSO-PC model. So for example, the states that are listed here, California, Colorado, Indiana, Massachusetts, New York, and Oregon, have been the most recent states to enact legislation in this space. California in particular released 2 bills to further codify their corporate practice of medicine doctrine and emphasize that private equity groups and hedge funds do need to stay out of any sort of clinical decision making. California also now requires that certain material transactions that MSOs or private equity groups engage in, they need to report those to the state. The other states the new bills focus more on transactional matters and how the corporate practice of medicine doctrine would apply to MSO-PC relationships. For example, Oregon most recently kind of did an overhaul on their corporate practice of medicine doctrine in terms of making it a lot more strict, or at least clarifying how they're looking at the structure. So they have indicated they're going to prohibit any sort of common ownership between MSOs and practice entities. We have seen these in other states as well, such as North Carolina. So what that means is if the friendly physician is the owner of a practice, they cannot have ownership in the MSO. And this is meant to prevent, again, any sort of clinical interference from the MSO into the PC if the state believes that if the physician owner has an ownership and interest in both entities, they might be more incentivized to push investor goals into the PC. So all that to say, it's very important that as you are thinking about the MSO-PC model, if you are in one state, 5 states, or all 50, it's important to note that these states are paying attention to these structures and are updating their corporate practice laws, or at least clarifying how they are interpreting how these models need to be structured to be compliant. On the flip side, it is also a strategic advantage if your model is structured compliantly, because that will stand out. So instead of viewing compliance as a burden or, okay, now we have to update all of our processes, this is going to cost money, it's going to take time, it's important to view this as an opportunity to have an enhanced strategy and stand out in the market. The MSO-PC framework continues to be the standard legal structure for digital health companies. So it's one legal model that has continued to be the primary standard, the primary legal structure, but there are many operational models that continue to expand. So the market has definitely matured from compliance workarounds to companies wanting structured governance frameworks that are recognized and approved by regulators. So compliance is definitely a differentiator when it comes to investors. And it's important to kind of be aware that the MSO-PC model, although it started out in primary care and behavioral health, those were the most common adopters. The model has become involved in a variety of businesses that are now using it. So in recent years, we've seen rapid growth in direct-to-consumer prescribing and diagnostics, remote monitoring and care management programs, telepharmacy, asynchronous-based models, etc. So it's important to note that some of these operational models are more restrictive in certain states. For example, asynchronous-based models, there are specific rules in certain states around this type of clinical care. But the MSO-PC model in general has definitely expanded into those areas. We're also seeing more specialty and condition-specific platforms, as well as workflows that incorporate clinical support tools. Also, AI is becoming more popular as well. So across this expansion, the mix of clinicians that are involved has broadened as well beyond physicians. Now we're seeing nurse practitioners, physician assistants, pharmacists and behavioral health professionals become involved as well. So while the legal structure hasn't changed from a foundational level, the operational diversity within MSO-PC models has increased dramatically, and this reflects a shift towards a more consumer-centered and technology-enabled model. So now we'll talk about some barriers versus opportunities from a few different perspectives: legal, financial, technological, and operational. When we're thinking about barriers, standing up an MSO-PC model across 50 states is a major undertaking, which is why a lot of startups and early stage companies start with a handful of states just to do kind of a proof of concept and see if this is something that's going to work in multiple states. The operational work that's required from a legal structure perspective, engaging in the corporate setup, making sure all the agreements are in place, licensing, compliance, also recruiting clinicians or finding a friendly physician, handling revenue cycle management and payer contracting can definitely be complex. Companies also have to develop scalable tech, build clinical workflows, manage labs and pharmacy integrations if that's something that's going to be part of the model, and invest heavily in marketing and customer acquisition just to get the volume needed to justify the upfront spend. Many founders as well come from academic, clinical, or tech backgrounds and sometimes may underestimate how difficult it can be to operate a compliant multi-state medical practice. So the barriers to entry are high, which is why we've seen a surge of telehealth adjacent businesses as well. These businesses typically focus on building a platform that they can then provide to the MSO. So mostly MSO enabling vendors are ones that are kind of making a move in the market as well. We're seeing some staffing and licensure organizations pop up as well because it can be difficult for an MSO-PC structure to kind of handle the clinician overload as well. Licensure organizations is something that we're seeing too. Asynchronous care infrastructure, specialty EMRs, telepharmacy and teleprescribing partners, virtual lab networks, and other clinical quality vendors. So we're seeing a lot of growth in these telehealth adjacent businesses as well. So if we think about these as opportunities, some might see these as obstacles and a barrier to entry. Others might see this as a market opportunity. So an entire ecosystem has emerged essentially to help digital health companies accelerate, launch, scale, reduce costs, or outsource some parts of the model that may be better handled elsewhere. This infrastructure is now part of what enables rapid innovation in virtual care. And once all of this is set up, you have a compliant care model that might open the door to a direct-to-consumer opportunity or other arrangements and relationships with practices or payers, etc. All right, so scaling. Once you have the infrastructure in place, we want to talk about your long-term goals and how to scale the MSO-PC model. There are a few key points to keep in mind. Those are timeline, thinking about your near-term versus long-term goals, what your primary offering is going to be, and finding an expert to help you along the way. The timeline concept really is important at the outset because scaling an MSO-PC model isn't just about growth, it's also about strategic clarity and sequencing your goals in an appropriate manner. You would start by grounding the team in realistic timelines. Scaling a multi-state clinical network, integrating compliant technology, and staffing appropriately all require resources and precise planning. It typically takes at least 3 to 6 months to build and launch this model. That's from starting with finding your friendly physician, getting those contracts in place, to then setting up those entities at the state level and launching. When we're thinking about near-term versus long-term goals, it's important to distinguish what is most important now and what is something that you want to focus on in a few months. What gets you to market quickly might not be the structure you maintain once you expand across states or add new modalities to your model. Companies often begin with a hybrid or an outsourced approach, and then they bring functions in-house once their practice is running and you have patients that are coming in pretty regularly, and that way you can justify the investment up front. It's also important to think about your primary offering. So your primary offering should guide your operational strategy. If your differentiation is your clinical care model, you may want to own the PC network and clinical workflows. So that means you wouldn't want to outsource. We have some MSOs who contract with networks, PC networks that are already standing. But if your primary offering does relate to your clinical care model, you would want to keep that PC network as an affiliated entity with the MSO. If proprietary technology is your core asset, then you may prioritize building in-house tech to avoid reliance on turnkey platforms. If the technology is not your primary offering, the MSO could always outsource that to a software vendor, and also making sure that contract is tight as well. So the clearer you are on this at the outset, the more scalable the model becomes. Sometimes we see, very innovative companies want to do several things at the outset, but that often causes delays because you're then managing several workflows and models, and it doesn't allow you to kind of focus on launching the initial infrastructure. So it's really important to be clear on what this primary offering is going to be. If the MSO doesn't have the bandwidth to build everything in-house to start, you can definitely outsource these services. There are several businesses, as we talked about, that are telehealth adjacent. They offer PC owner services. So if you don't have a friendly physician in mind, for example, there are several companies who are kind of recruiting these types of clinicians for this role. The PC network, as we mentioned, some MSOs contract with an entire PC network outright. Provider networks are another piece that the practice could outsource in terms of deciding, which clinicians they want to bring in to provide direct clinical care to patients. Platform services, if the MSO doesn't want to build the technology in-house, they could definitely hire an outsourced vendor to provide the software platform for them. And licensing and credentialing. We often hear that when MSO-PC networks are trying to get their clinicians or their friendly physicians licensed and credentialed in several states or with several payers, it can often take a lot of time, or it is kind of an administrative burden for some companies. So there are entities who handle this for you. You can also take advantage of the interstate licensure compacts that are in place for certain clinician types, and that can often help with scaling, or at least getting the MSO-PC model off the ground to start. And lastly, it's very important to find an expert who can help you with this. As we mentioned and talked through, there is a lot of complexity from an operational and regulatory perspective. So it is important that you hire legal counsel or an expert to help you understand the different state implications that are at play, whether that's corporate practice of medicine, licensure, payer rules, if you have artificial intelligence in your model, how to help with that oversight, fee structures to ensuring that you are going to be complying with fee splitting laws and other state-specific nuances. So engaging an expert can really help you tailor your documents and governance to make sure that they are compliant with state law. And also, experts often have seen these models become implemented across the last 5 years, for example. So oftentimes we can kind of see from an operational perspective as well how you may want to set things up or how you might want to structure your business strategy. Sometimes there are generic MSO-PC templates out there. However, these are not going to protect you at scale and can actually create risk from a corporate practice of medicine perspective or from a fee splitting perspective. Oftentimes there's no guidance on how to structure the management fee People might recommend a percentage-based fee, and as we talked about, that is going to put you at risk from a state perspective. So when you're thinking about scaling, definitely think about these 4 things and ensure that you have legal counsel ready to help you. All right, that concludes our MSO-PC Model 101 video for today. Again, thank you for joining. I hope that you found this information helpful. If there are any questions, please feel free to reach out and we would be happy to help you. Here's a QR code where you can access our website and get in touch with us for if you have any questions or if you need more resources. And here's a little bit about me if you'd like to read up. Thank you.